Thanks everyone for joining us today. I'm Jillian Graber, Executive Director of Protect PT, and we have one of our legal interns here, Nija Brown. She has been with us since since 2019, summer of 2019. Is that right, Nija? So
Yeah,
she's been with us for a while, and we're really excited to have her here today. We're going to do kind of a pre-hearing to our Supreme Court hearing today. So we're going to talk a little bit, and then we have actually a pre-recorded video from our attorney who's going to be live at the Supreme Court at 10:30. That's when we expect for them to start the case. So we're number 3 in the docket today. So we're not quite sure exactly when they're going to start, but we're prepared. So we're going to go live to the live YouTube stream when that happens, and so everyone can view it on our website. And we in this format we really can't take questions, but we are going to post it on YouTube afterwards. So folks, if they have questions, you can always email us. My email is Jillian, Gillian at protectpt.org, and just check out our legal advocacy page for the other legal work that we're doing. We do have another case coming up with the Environmental Hearing Board in September that we're preparing for the Draculic well pad, one of the 11 well pads permitted in Penn Township, which is going to be kind of a big discussion today with this case. But first, we wanted to kind of get to know Nija a little bit, because she has been such a really wonderful part of our team for the last few years while she's been finishing law school. She's just a rock star. So she worked with us in the summer of 2019, and then we kept her on part-time to work with us as she could while she was in school. So we're really excited to have her here today. Thank you, Nija. And yeah, so congratulations on recently graduating from law school. It's really exciting.
thank you.
And
Thank you.
you're taking the bar what, next week?
No, it'll actually be a little later in the summer, but
Okay,
in the next few weeks, yeah.
great. And then you're going to be starting to work in a firm in August. Is that right?
Yeah, August or September, still pending a final couple details, but yes.
That's
Hmm.
exciting. Yeah. And so we're going to be following you, through your career and everything. And we're really excited that we got to be a part of it. So why don't you tell us a little bit about like what you've done with us in your time with Protect PT, and kind of a little bit about the case.
Yeah, well, thank you. So I guess I did start back in 2019, as Jillian mentioned, and a lot of things I've worked on included research, just drafting, whether was for the lead attorney, just general brief information or case summaries, researching the legislative history of a lot of statutes that govern oil and gas operations, from the permit through compliance and everywhere in between. I think specific to this case, most recently we've been working on our initial briefs and response briefs, reviewing opposing counsel's briefs, and also the amicus briefs, just to prepare for today. And I think just kind of focusing on what their weaknesses are and how we can best plan our attack on their arguments.
Yeah, and Tim's going to talk about that a little bit. We've got a conversation that we had with him a couple weeks ago, and so that we felt like we could pre-record that. It would be some really good content for today. But so like we're going to talk about some of the main arguments that the industry brought up, but tell us a little bit, because this is something we didn't really get a chance to talk about in the video. Tell us, so like there were a couple amicus briefs that the industry put forth, or I should say the defense in this case put forth to try to strengthen the argument of, in this case it's Olympus Energy, formerly known as Huntley and Huntley. And so with that, what are some of the main arguments that they said were kind of, that they were depending on for their defense?
Yeah, so I believe there were three amicus briefs, and the messages were pretty consistent. It was that, the United States and Pennsylvania specifically, and then the Southwest region just basically can't function without the oil and gas operations. And if we add any more regulations, then essentially the cost of the filing fees, the cost of operations, employment, and everything else will just skyrocket, and it won't be affordable for the everyday consumer. And I think the main problem that a lot of these arguments had is they just fail to overlook the public health implications. And it really just wasn't even brought up. And not only that, but many of Protect PT's arguments, which Tim will address, just weren't even responded to in any substantive context. And it was just more about the financial impact. And you could clearly see that all of the amicus briefs, they were focused on their bottom line, which is not what the focus should be. Oh, I don't know if you're muted, but I can't hear you.
Oh, there. Sorry. Thanks. Thanks. That's like the phrase of the century. I think you're muted. Or I should say of the last year. So I think that one of the things that we discuss, and maybe we could talk about a little bit, because you experienced this when you were an intern with Protect PT going to a local hearing. So I want to kind of explain that a little bit to people, because for folks that are watching and maybe this is the first time they've seen development in their local town, and they're just not sure what to do. So Nija had a pretty good kind of a view of this when she was an intern with us, going to local hearings. But when a new type of well pad or any kind of other infrastructure is proposed, if the local municipality has zoning, which in this case Penn Township does, depending on what the ordinance says, the company would have to go in front of a board. So whether it's the Board of Supervisors, or in this case, it's the Zoning Hearing Board. And so, you got to see the Zoning Hearing Board a little bit when you were interning with us, because we did have a case that we were working on at the time. But that decision then from the Zoning Hearing Board can get appealed. And so we have been through that appeal process within the last couple of years. So first it was appealed to the county, and at the time, we were really unsure if the county was even going to look at any of our evidence. That's one of our arguments, right? That the judges, and in this case, it was the Commonwealth Court judges, didn't do well, I guess it goes back to the Zoning Hearing Board. They didn't do a meaningful review of the evidence that we brought forth. And I don't know if you remember, Nija, when we were at the local hearings, and if you got to experience this, but when we engage in a hearing, not only do we bring our own experts, but we also bring there are people that attend the hearing that make public comment. So I don't know. I know it's thinking back to a couple summers ago, but what were some of the things that you noticed about people, or maybe some things that you noticed about the hearing that kind of stuck out for you?
Well, I know it's towards the end, but I think actually one of the most important things are the public comment, as you mentioned. And I think, a lot of people don't realize how many people actually do come out to make public comment, especially if they're not directly within the zone being impacted by such operations. And it's actually really disappointing how little weight the boards seem to give to those opinions, because those are the people who will eventually be directly impacted, sometimes for many years. And it could go on for even after the operations end, whether it's the water, the air quality. Either way, I mean, those people have to live with that. And even if they want to leave, they oftentimes have difficulty because of the property values associated with being in close proximity to such operations. So I think that definitely. And then another thing I would say is just how much preparation that the oil and gas has in terms of big name attorneys. Like, Protect PT works so hard to protect the community interests. And I understand it's the attorney's job. Like, I fully get that. But it's just, the oil and gas has almost zero consideration for public health. They rely on these old statutes and regulations that are clearly outdated, and they just take complete advantage of them. I guess the last thing, as an extension of that I would say, is that the board as a whole, and this isn't always the case, but it seemed like more often than not, would just be overly deferential to a lot of the oil and gas companies, despite the scientific studies Protect PT would present, and then also the problems that the residents would point out.
Yeah, and I do want to clarify too, not in this case, not only did we have the public comment, which is super important, as Nija put up, talked about, but we also had residents that had experienced impacts that actually opined on their impacts, and were cross-examined. So these were experts that, or these were their fact witnesses. So these were people that were individuals that lived around shale gas development in Penn Township before. They experienced what it was like to live around the operations, and they actually told the zoning hearing board what their experiences were, that their life was impacted, that they feel like their health was impacted, that their life was upended by this type of development. And I think that that's really important, because not only did we have Dr. Walter Sue, who's a really well-known public health physician in the state of Pennsylvania, but we had also Nurse Laura Dagley from Physicians for Social Responsibility. Both of those experts talked extensively about public health impacts, and I actually had you go back and look a couple weeks ago, to prepare for the hearing. To look to see what they talked about with cumulative impacts, because that's actually one of the arguments that we brought up, the impact of the 2 well pads. This is an interesting thing, because generally at a hearing you have to really focus in on the 1 well pad and how that particular well pad is going to impact the community, which I think we clearly showed. But in this case, there's 2 well pads, and in Penn Township, there are 11 well pads total that are going to be built in the area. And but these 2 pads are particularly in close proximity to each other and to the residents surrounding. So, and there's another well pad too, not too far away, that they've already developed. And so that well pad that was already developed is actually what those folks talked about, the impacts. And this was a Huntley and Huntley, or Olympus Energy well pad, the Poseidon well pad that people had impacts from. And they talked about that, and how it impacted their lives. So, we're not just talking about our public health experts that are super knowledgeable about public health impacts and how this particular development was going to impact public health, but we also had direct testimony from residents that had been experiencing those impacts for themselves. And then on top of it, as Nigel was talking about, we had the public the public participation, the public comment. So when you're at a hearing, there's an opportunity, if you are a party to the hearing, like we were with Protect PT, there's an opportunity for you to bring those fact witnesses, which we did. There's an opportunity for you to bring those experts, which we did, and as well as standing witnesses, because that's been always something that the company loves to say, well, you don't have standing because you're an organization. But can you talk, I don't know if you remember at all, like how we gained standing, or how we proved that we had standing in this case. Do you remember that, Nija?
Yeah, so standing, it basically has 3 requirements. You have to have an injury in fact, it has to be caused by what you're making your complaint about, and then you have to have a form of redressability available. And so Protect PT, as a nonprofit, they can actually gain associational standing And that means that on behalf of its members, if their members are impacted, they can bring suit. So in this case, basically what Protect PT's goal was is to show that its members would be within a close enough area as defined by the statute that they would be harmed based on the operations of the oil and gas wells at issue in the particular case. And so we had to show basically a map and say, okay, here's where the oil and gas operations will be. Here's where the resident lives, or multiple residents, as it was in some cases. And this is the health impacts that they're likely to experience, and then basically show also what we would be seeking in terms of remedy.
Yeah. Yeah, that's a great description. Thank you. Yeah, and so every time this comes up, you know, we have, because we're a community organization and we have membership, we are always able to overcome that challenge. In fact, we don't take on challenges, you know, legal challenges like this, and participate in public hearings if we don't have standing. That, because that's the number one thing that we're going to come up against, right? So knowing that, and that's why we're a membership organization. So if anyone's out there and they're, you know, wondering, well, why would maybe Protect PT want to be involved in something near my house? The first thing you want to ask yourself is, are you a Protect PT member? And are your neighbors Protect PT members? Because the more members we have in an area, the more ability we have to, you know, to really participate in that public hearing and, you know, really dig into that case. Now, that's not to say that if we didn't have members, if we had, you know, one or two people asking us to participate, perhaps we would, you know, help them do that for themselves. You know, maybe there's another smaller group. We actually did that most recently with the Tri-County landfill in near Grove City. Someone asked us to help out with just preparing for the hearing. We were happy to provide that mentorship. That's another thing that we do with other organizations. We partner and collaborate with other organizations and provide mentorship for folks to kind of prepare for the hearing. So trying to gather those experts, you know, we're really lucky that over the course of the 6 years that we've been, you know, working in the community, that we have gained these wonderful relationships with some really amazing experts. And they've either come to our aid, or, you know, we've asked them to come to others' aid. So, you know, you actually can go back and view some of the old YouTube footage from Nurse Dagley's testimony from this hearing if you want to. So if you want to get some more historical content, and I will say she kicked butt at the hearing, especially up against a really nasty attorney. So I got to give props to her and Dr. Sue. They just did a phenomenal job. And so, you know, part of what we're going to be discussing today is how they were ignored. So we're going to go to our video right now. And we're going to talk a little bit more with our attorney, Tim Fitchett, who is with Fair Shake Environmental Legal Services, about the case. And then we're waiting for the Supreme Court to start our case. And when that happens, we're going to go live to that stream. So just stay with us. And Nija's going to stick around just in case we have, you know, some time after the video before the case starts. So stick around.
Thanks, Jillian.
Yeah. Thanks for being here with us today, Nija. We really appreciate it. So we're talking today with our attorney, Tim Fitchett from Fair Shake. He has been with Fair Shake for about 1.5 years. And recently became our attorney, and so we're really happy to talk with him today a little bit about our oral argument that he's going to be doing this morning. So this is pre-recorded, and this morning he's going to argue in front of the Supreme Court for our Gaia and Metis cases. So thank you so much, Tim, for taking the time to be with us today, and maybe we can talk a little bit about the cases. So, Tim, what do you think are kind of the key points in this case?
Yeah, so the two big questions that the Supreme Court took up were whether or not the Commonwealth Court's opinion conflicted with the capricious disregard of evidence standard. And so this capricious disregard of evidence is whether the lower court, or the zoning hearing board in this case, had failed to take into account apparently reliable evidence. And so that part is, we can go into more detail in a little bit, but that's talking about, we had our experts going up there and, their facts and findings of fact and conclusions of law, which is this document that the zoning hearing board needed to create after the hearing down below. They needed to take into account and satisfactorily discuss the different experts and the facts that were put in front of them. And then the second question is whether there was a failure to evaluate the cumulative impacts of the multiple wells that are in this region. And so we were arguing down below that the multiple wells all within a small region were, should have been looked at cumulatively as opposed to just sort of individually making sure that they, comply with the regulations.
Right. And I will say that this is well pad, I guess it would be 11 and 12 in the in Penn Township. And so I think that was a question that when we went to the Commonwealth Court, the judges kind of thought about a little bit and questioned, but still the ruling kind of didn't reflect that concern. But there was one concern that was brought up by one of the judges. Do you want to talk about that a little bit?
Yeah, so a lot of the case and the argument that we're making is sort of predicated on Judge McCullough's concurring opinion in the Commonwealth Court. And what she said there was, in this case, I believe that, all of the precedents, so all of these other court cases that have come beforehand, she said, I think that they complied with all of this, right? And so I have to concur with the opinion that we have to affirm the zoning hearing board. But what she said was, my issue is that I don't like the precedent. She said, I don't think that it gives enough for, these groups. And essentially was asking, what more could Protect PT have done, right? And how could they ever win if, this is the state of the precedent? And so, that's sort of the third tier of our argument on that point, right? And so I can kind of walk through those pieces. So the current precedent requires that the hearing board give a meaningful explanation of why they didn't listen to certain experts, right? So the finder of fact, who, in this case is the zoning hearing board, there's a lot of deference given to them, right? And so when it's up on appeal, in this case, it went on appeal at the Court of Common Pleas and then the Commonwealth Court, and now we're on a third appeal up at the Supreme Court. Those appellate courts are meant to give a lot of deference to the finder of fact and make sure that they, and because they're not in front of them, right? The zoning hearing board is the one that's hearing these experts. They're the ones that are having the conversations. They're able to, really dig into it all. But the court cases have said that you have to have a meaningful explanation of that. And in this case, for particularly Dr. Sal, in the findings of fact from the zoning hearing board, they kind of just mischaracterized his testimony. They mischaracterized the evidence. And so he had submitted an expert report. And in that expert report, he had cited 40 odd cases. He had talked about all of these different medical harms that could come by being close to well paths, by being in close proximity to them. And the findings of fact and conclusions of law said, one, that Dr. Sal testified just to studies that were based on self-reported symptoms. And that's just not true, right? He cited, that was 7 of the 40 plus cases that he cited to were about self-reported symptoms. And so there's this question of, is that sufficient, right? Was that a meaningful explanation? Because what we argue is it kind of looks like you listened to the first minute that he spoke, and it kind of looks like you just read the first 2 pages. And then the other, 8 pages of the report were kind of ignored, right? And so part of our argument is, was there a meaningful explanation under Hinkle?
Judge McCullough had kind of questioned, well, if this is not enough, then what is enough? And we kind of thought the same thing, and when we went to the zoning hearing board, and and then we went to the county court and then the Commonwealth court, we were questioning whether they even looked at the evidence that Dr. Sue presented. And
Mm-hmm.
we questioned, well, if we as Protect PT, who is very, very organized, and we had a lot of public input in, and we had, in the hearing, that's the public comment portion of the hearing. We had these wonderful experts like Dr. Walter Sue and Nurse Laura Dagley, who were so generous with their time to be able to come and testify for us. If that wasn't enough, what is enough? What is going to be enough? And is it always going to be us against these large corporations and the ruling always go in their favor? And so
Yeah.
what do you think, what do you think that we could do to change that? Or do you think that this case will change that at all?
Well, that's kind of the hope, right?
I'm gonna do this to my friend.
Beyond this kind of existing precedent and saying, look, their sort of cursory dismissal of all of this was insufficient. And that goes, they say the witnesses weren't credited, and that's sort of the end of it, right? And as the precedent currently stands, that's okay. It might be okay, right? We're kind of arguing it's not, but it might be, right? To just say that it's not. And, how can you say that about Dr. Sue, right? Like, how can you just say he's not credible? It just doesn't make any sense whatsoever. And so our much more, deeper change the precedent and, policy-based argument is you have to, one, give something for the appellate courts to go off of, right? As it stands right now, one of the arguments that we make is they can kind of just say magic words, right? And if they just say your experts were not deemed credible and the evidence of the other side was believed, then just poof, right? Our case is gone, and the appellate courts cannot overturn it. And that's all they have to say. They just have to kind of explain the evidence and whatnot. And so part of our argument is that's not enough, right? You can't get meaningful appellate review when really all they're looking for is a couple magic words, right? And I make the argument directly in this case. And I say, if you affirm the decision down below, then you are just giving the directions to every zoning hearing board and every agency across Pennsylvania to simply use magic words, and their decision can never be overturned. Because again, how can Dr. Sal not be credible, right? And so on a larger sort of policy standpoint, in order to, I think, get more meaningful decisions, to be able to get meaningful appellate review, what we are essentially asking the court to require is a more meaningful explanation, and for those boards to actually have to talk about why, right? Why did they believe one side over the other? And they can still make bad decisions, right? I mean, this isn't going to be some, a Kevlar vest to avoid environmental damage, right? But what we want is for those people on the zoning hearing board to have to say, we wanted economic benefits over the potential harms to, right? For them to actually have to say that, put it down on paper, right? To put why they're making the decision, as opposed to being able to have this very much the smoke screen, right? Like, we don't really know why they made the decision that they did. We don't know why they said that he wasn't credible and their people were. They just are able to say that, and the public is left not knowing,
Yeah.
and them not being held accountable, and it allows this kind of development to just go on.
Yeah, and do you think that the Attorney General's report and the what came out with the grand jury, the grand jury report, do you think that that had any influence or any any way with the Supreme Court taking up this case? Because this is not the first case that we've had that we requested the Supreme Court to take up, but this is the only one they have. Do you think that made a difference?
It may have come about because of those, and just sort of the general, change in temperament of the public for, the kind of natural gas fracking operations, and all of the, bad decisions that sort of that AG's report pointed out that have been made. If we don't have a meaningful appellate review and these things can just get passed, then how can we fight it? But I really think that the reason that they took it up was more because of Judge McCullough's concurrence. The Supreme Court often, they want to take up ideas that are important for the public. They also want to take up areas that are novel areas of law, but also when there's sort of a disagreement, right? They hold their colleagues in high regard. And so when one of their colleagues is willing to come out and take the extra time to write a concurrence that says, I agree, I have to affirm because the Supreme Court has already said that this is it, and I am bound by that precedent, but you're wrong. That's what she said in her concurrence was, I have to follow it because that's my place on the hierarchy, but you're wrong.
Yeah.
You need to rethink this.
Yeah.
And that's something that they will, take up, to help elucidate that, right? They know that she's not writing that for no reason.
We know what some of the arguments of the opposition are, but can you talk to me a little bit about what those arguments of the industry are, and maybe what you think they're going to present in their oral argument?
Yeah. So I think the first part, in regards to like Dr. Sal's testimony and the capricious disregard, they're going to say this is a really high bar, right? Capricious disregard, it's a high bar, it's tough to cross, and that goes back to that deference that they owe to the fact finder, right? And appellate courts really don't want to overturn the fact finder, right? It has to be pretty blatant. And Taliaferro, one of the cases that's really important in this, says that it has to be a deliberate disregard of apparently reliable evidence. And so, we're making the argument that they deliberately disregarded it by mischaracterizing it, right? That shows, like, how else could it be a deliberate disregard other than just not talking about 80% of the testimony? I think the main point on the larger policy argument that we're making, right, that we were just discussing, is whether such a standard would overburden the zoning hearing boards, right, and overburden these agencies. And that's something that, this had an amicus curiae brief from the Pennsylvania State Association of Township Supervisors is arguing that requiring this of them would take so much more time, right? And these are volunteers, and my goodness, how can we possibly ask more of them? They are graciously donating their time for their communities and blah, blah, blah. And they go to these hearings and they're unpaid. And, how can we possibly ask for more? And to which, in my reply brief in this, I say, well, charge more, right? They try to make the argument that it has to be the public that is paying for this, extra time, right? The extra lawyers' fees to come up with the findings, facts, and conclusions of law that will satisfy, the standard that we're asking for. And, I argue that it's a false dilemma, right? And they're saying the option is either the terrible precedent that leads to all of the problems that we are currently seeing with a lack of appellate review, and competent witnesses being thrown out, right? Incompetent evidence not being looked at. They're saying it's either we keep that standard or the public is going to pay tens of thousands of dollars more in order to make sure that we handle that. And it's a false dilemma, right? If it costs that much more for the public to have appropriate review of these very serious issues, then charge the company that's going to be making millions of dollars. Don't lay it on the public. There's no reason for that at all.
Well, I think that kind of goes back to the duty of the board. I mean, the board's duty and their mission is to make sure that the proposed development in the first place does not harm the public. And so if they cannot do an appropriate review because they don't have the time to do that, then they should not allow the development. And in this case, unfortunately, they have to in the state of Pennsylvania, but that doesn't mean that they can't charge more for their application fees, right?
Exactly. It'd be a relatively simple process for them to increase the application fees. They say, look, if you want to put a fracking well, that's fine, but it's going to cost you $30,000 because we need to make sure that we do it right. Yeah, so their big argument is that it's going to be very burdensome and we can't possibly ask for that to happen. And yeah, I think that it's right. It's their duty to ensure that this is protective of public health, right? And that requires some appellate review, right? If there's a valid reason to do that, then that requires appellate review, and that appellate review shouldn't just be rubber stamping the decision from down below, right? If it's just rubber stamping, or if there are magic words to let them get through, then it's no longer appellate review.
Yeah.
Right? Doesn't. It's just not. And the dilemma that they are proposing is we have to allow bad decisions to be made because otherwise it would be really tough.
So how do they justify our point for cumulative impacts then?
So cumulative impacts, they essentially say that their main argument is that we didn't actually show enough. Because when you're dealing with the cumulative impacts, you have to show that there's a substantial detriment beyond that would normally be there. And so that their argument is that we just didn't show enough, right? That we may have shown that there were going to be some other impacts, but we didn't show a substantial likelihood. And this kind of gets wrapped back into the first question, because we are essentially saying you should have listened to our experts. You should have looked at all of this, these cumulative impacts. We should have looked at this information, but they were able to get around all of that by simply saying, well, we didn't believe any of it. Right? They said, Dr. Sal wasn't credible, and your evidence wasn't credible, and we believed the other guys. Right? And so by saying that, and again, going back to the deferential standard that the appellate courts owe to the fact finder, they're kind of able to just skip over and say, well, the fact finder said you didn't show cumulative impacts that would cause substantial harm, so they weren't there, and we're done. That's their main argument.
Interesting. Nurse Laura Dagley talked a lot about impact and I think she talked about cumulative impact as well. Because knowing, we knew going into the hearing that there were going to be two pads close together. So we knew that there are going to be cumulative impacts. And I believe specifically talked about that in our cross-examination and in our direct examination of our experts. And, I think one of the problems here is the way that air emissions in particular, that's one of the impacts that's, definitely, air emissions are doubled. Truck traffic is doubled. All of the impacts are basically doubled in this case because we have two well pads very close together and they're going to be traveling, some of the same roads. It's a small area, so those folks are going to experience the same impacts with both of the pads. And we also have the air emissions. The way that they're calculated they're really just a model. So they model for them, right? They don't actually monitor, don't actually give an actual quantity of air emissions. They say, well, we think based on what is typically done at a well pad, that this is what the air inventory is going to look like. This is what the air accumulated impacts are going to be as far as the air emissions. And that's not going to be, they always make the argument that's not going to be an issue. But what they're not talking about is there are multiple wells that are usually drilled and fracked at the same time. They're not talking about that two pads could be done at the same time. So essentially they would, drill and frack wells at one pad, then take the equipment and move it to the next pad right next door. Those, and so they don't talk about that. And that's one thing that we talk about in the hearing, but they don't want us to talk about that because they don't want us to think about all of these accumulative impacts because they want to do business and they want to say that their business is not going to harm us. So I think just from being in this fight for several years, that we showed everything that we needed to show to be successful. I'm just hopeful that the court sees that, does read through the entire testimony or read through, do you think the court's going to read the record? Because we present a record, right, from the the local zoning hearing board is where we develop this record and develop all of our testimony, develop all of our questions and all the answers that the industry gives, and we take that package, that record to higher courts. And so that's we spend a lot of time and a lot of effort making sure that record is solid. Knowing that that's going to be used, that we're not going to introduce any new evidence.
I think the court's likely to read through, especially the points that we point out and that the opposing party points out, the portions of the testimony and the transcript. There is a reason for having the reproduced record, because there's the just as a side procedural note, there's the record, which is every single bit that got put in down below. And then there's the reproduced record, which is a somewhat trimmed down, but still 1,200 pages in this case, of, portions of the transcripts and stuff like that. They will likely have a clerk read through most of that just to make sure that there's nothing that's out there. But I doubt that every single justice is going to read through all 1,200 pages. They'll focus on the pieces that we point out to them.
That's interesting. So, yeah.
That may be incorrect, though. I'm not entirely sure. Functions, and I don't want one of them to see this and be like,
we read through everything.
We read everything.
It'd be great. It'd be great if they read through everything, you know?
Yeah, but the big issue, even if they do read through everything, is, and it's one of the reasons why there's the deference to the fact finder down below, is because transcripts are sterile, right? You can read things a lot differently, right? I think every person uh, in the world at this point has had a text message that was misinterpreted, right? They miss the sarcasm, they miss the joke that you're trying to put in there, and that's the kind of nuance that gets missed, right? You can't tell how you know uh, 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 I don't know, trying to skirt the question somebody is from a transcript. So that's something that why there is great deference, but also why it's important for appellate review for these findings of fact and conclusions of law to be robust, right? For them to really explain why they believed one person over another, explain why they found, a witness to be not credible, as opposed to just a blanket statement that they were not credible. Because again, all that effort to build that record, all of that goes into getting that record together, getting the comments, getting the scientific studies, getting the testimony, all of the hearings, all of that stuff. If the hearing board can make whatever decision that they want and have it upheld on appeal by simply using magic phrases, then what's the point?
Do you think that on this point, let's say that a zoning hearing board were to say, we didn't find the industry's person credible. And,
Yeah,
and do you think that, this could work against folks that want to develop and zoning hearing boards to say, no, we just don't want you to, or we didn't find your testimony to be credible. This
100%.
this could work the other way, right?
Yeah. I make that exact argument in my reply brief, and I say, Olympus should be just as worried about this because they could, go and they could put up 15 experts who are perfect in their field, and we could walk in with one random person from the local community college, and the board could just say, well, we believe the community college guy over your 15 world-renowned experts.
Yeah.
Right? And in the current state, and if these magic words and phrases are approved by the court, then they could appeal, but nothing would happen. Right? Every single, just as happened in this case, the courts would say, well, they talked about your testimony, they summarized it, and they said that they didn't believe it, and they said that they believe they're this expert over that expert, and so sorry, you're out of luck.
Wow.
So it is. I think it is. It's all of this is to try and avoid arbitrary and capricious decisions, right? This is sort of the standard for admin law, arbitrary and capricious decisions. And the idea is that you don't want an agency kind of ex post facto justifying the decision that they already wanted to make, right? You want them to be looking at the evidence and making a decision based on that evidence. And if all they have to do is, if they never have to really analyze the evidence that's put in front of them and resolve the differences and explain why they found this evidence is better than the other evidence, then it's just an arbitrary and capricious decision that's sanctioned by these magic words, and that will get sanctioned on appeal because the higher courts can't do anything about it.
Yeah, so it's kind of like it undermines the judicial process altogether, right?
I think so. You need to be able to have an argument.
Yeah.
Right? You need to have something to be able to latch onto and have some teeth to actually be able to overturn this. And the current state of precedent doesn't allow that.
Yeah.
It just doesn't have any teeth to actually overturn a decision. And it's a different situation when you are just not pleased with the result. Right? And they try to kind of make that argument as well and say, well, Protect PT is just throwing a fit because they don't like the decision that was ultimately made. And yeah, we don't like the decision that was ultimately made, but really it's about the way that that decision was made, right? And ensuring that decisions are not made arbitrary and capricious.
Well, and especially like when you have a community group like ours, like we're a grassroots community group. We have to raise money to try to get these, to if we're going to pay an expert, right? We have to raise the money to do that. We have to find the expert that's right for this with very little resources, and prepare the expert for for testimony. And to be ignored is, when you've put all that effort and all these very precious resources towards doing that, then and they ignore them and don't even give you a good reason as to why they ignored them. It's very I'm angered by it. It's it's not we're pitching a fit because it didn't turn out our way. It's no, we're pitching a fit because you ignored us. We put all this effort into it, and it's almost like we put all this, all this effort and all these resources, yet the township who's making the decision didn't want to do the same thing, didn't want to put in the effort to, to have appropriate findings of fact and conclusions of law that outlined why they felt like our expert wasn't credible. So what's next after, we go through the oral argument, and what's kind of like the next step, or what can we expect to happen next?
Well, so the oral argument will happen, then the court will take as much time as it wants to make their decision. You do not get to press the Supreme Court. They make decisions as they make decisions. So we will just have to be patient and wait.
Okay. So we're back. Hi, Nija. So that was our pre-hearing video that we made with Tim, and actually, we were just taking a look at the live feed from the court, and it looks like they are still. They just started the second case, so we've got some time to talk a little bit more, and so we have some comments in the chat, and I'm going to try to go to those comments in the chat. But first, while I'm doing that, do you have any kind of takeaways from what Tim was talking about in his video?
Yeah, I think one thing I just want to emphasize is the arbitrary and capricious standard that he was talking about. I think he did a very good job of explaining it, and I just think that the emphasizing how tough of a standard that can be is really important. And it might seem like whenever the Supreme Court does hear the case that they don't focus on this like individual specific facts, like he mentioned that they may not go through the full 1,200 pages. And so, and I think as he also mentioned, there is some level of deference that they will give to the facts. So showing that the board didn't fully consider those facts can be a burdensome task. But I think we've prepared well, and I think Tim will show that once it's our turn. But I think that's just something to keep in mind whenever everyone's listening to the oral argument.
Yeah, that's true. So I just pulled up our live stream of our video. And so, yeah, so we know that the court, they have, I looked at the docket, they actually have 4 cases today, not 3. And so they had originally told our attorney that we would start it at 10:30. And so they actually just started their second case, so they're running a little behind today, but we're going to keep talking about the case, and we'll broadcast it live as soon as it starts, just to give some context. And so we do have some folks in our YouTube that are chatting right now, and thank you to those that are watching, because you can go back and watch this later, but this is the case that we, out of all of the cases that we have participated in the zoning hearing board, and then taken to the county court and then the Commonwealth Court, this is the one case that is going before the Supreme Court. And so in the video, we talked a little bit about that. But I think the one thing that, just from conversations with you and Tim that we've had, the one thing that really is, that makes this the case that they brought, is not only, what we talked about with Judge McCullough, and we talked about with, potentially the AG's office coming out with the grand jury report may have been one of the reasons, but there's also, the court found that this was of great public importance, and so that's important to note, because I guess unlike our other cases, they found something that was different with this case, and so we're really happy that they took up the case, and I hope we prevail. But I was recently asked by other folks. There was a case, Allegheny Township. It was I think it was Frederick versus Allegheny Township, I think is what the case was a few years ago. And they had asked the Supreme Court to take up their case as well, and they didn't. I was recently contacted by somebody that was involved in that case, and she kind of wanted to know like what we were doing that was different, and I don't think we did anything different, except we did prepare really extensively for the hearing, and we did talk, have these public health experts, and I'm not sure what they had in their case, but I think the big thing was the judge. So yesterday we voted here in Pennsylvania, and so I just want to make sure that people understand that the judges that you vote for have an impact on what some of the outcomes of these cases, especially where we have this really great public importance. It's really this very classic, David versus Goliath, scenario here, where we have, a small group of people, residents that just want to protect their community versus a large industry that has lots of money. Nigel was talking earlier about, they're lawyers. They've got, this tremendous amount of resource to get the best lawyers. And when we go to court, it's like our one lawyer against their, 5 lawyers sometimes. And it's just, and their consultants that they pay to cherry pick these public health, peer-reviewed studies. They cherry pick the ones that show what they want them to show, and they don't actually look at them as a whole, which is actually what Dr. Sue did and what Nurse Dagley did. They looked at the peer-reviewed science as a whole. So I do want to give an additional shout out to PSR, Physicians for Social Responsibility, PA. Thanks to them, we were able to bring these 2 really highly qualified experts to the hearing. So I wanted to just kind of give everyone an idea of what people are chatting about online while we're waiting for the next case to end. So thank you to those that are online watching. And we have one comment. I'm impressed by Protect PT's attorney handling the case. Good luck with when time for our oral argument. Praying it goes our way. That's true. And we also have, what time is the oral argument supposed to start? They were telling our attorney 10:30, but unfortunately the court is late. If you There will be kind of a break between each case, so we will be able to see exactly when the case is done, and we'll be able to go and switch to that live stream. So just stick with us a little bit. I know this is like a lot of material that we prepared some ahead of time, but we're just talking really about some of the previous history that we had with Protect PT. And so what are some other comments? So we have Lois and Ron are on here supporting us and watching. Thank you guys for watching today. I'm not sure if anyone else has any questions, but Naja, from what Tim was talking about, are there any other things that maybe we didn't talk about so far that you wanted to bring up, or maybe some of the previous work that you've done with us at Protect PT you want to talk about?
Sure. So the first thing, just about the timing question, I will say, so at the appellate level, just so everyone kind of understands how that works, those are scheduled far in advance, and their clerks will generally give the attorneys how much time they have to argue their side, which they may preserve time to make rebuttal arguments. But if the justices decide to ask questions, and it could be many questions, it could unfortunately just run a little late. So we'll keep monitoring it, but that might be what's happening and why it's a little later than we anticipated. And then just switching to some more of Tim's comments, I just think that going through and all of the evidence, and I think one of the biggest things, which Jillian also mentioned, is that the boards just have this ability to arbitrarily decide that one expert's opinion is more credible than another's. And I think that's one of the biggest things that Protect PT is working to challenge. Just and not even just in this case, but in cases in general, that level of deference given, just because they don't have to give proper explanations to the decisions that they're making, which are clearly of great public importance.
Yeah. And actually, what you said really made me think about something. So, in Penn Township, just to kind of give you people history of what, what the well pad development and the zoning hearing board rulings generally were. So back when we started organizing in 2014, 2015, there was one well pad, the Quest well pad, that was approved. There were great impacts to some of the residents near that well pad, and they talked about that. And so every hearing that we participated in, because that was our first, we gathered more knowledge and more information about the process. And then we were able to bring that information to the next hearing. So then the next hearings were for 3 well pads. So the next 3 hearings for Beatty, Draftina, and the Beatty, Draftina, and White well pads in the township. And so those 3 well pads, we had some experts, and we also had testimony from folks, but we did not have the level of experts that we did at these hearings. We had very few experts at the time. We didn't know anybody that would be willing to testify. We didn't have the resources to pay anybody. So so we really relied heavily on those fact witnesses. And one of our witnesses was a local resident talking about the impacts of the Quest well pad. And just from that, and also from the testimony from the people at the hearing, the public comment portion, in addition to our attorney cross-examining the industry's experts, though there were 3 denials of all 3 of those well pads. So Beatty, Draftina, and then the White well pad, one after another. And this was at the time when Penn Township was solidifying their ordinance. And because of those denials, the industry really was shocked and taken aback. And so they sued our township in federal court, which was not the appropriate, we argued it wasn't the appropriate place to bring this lawsuit, but they sued in federal court, which tends to be very leaning towards corporations. And this is a big point because unfortunately in this country, sometimes corporations have more rights than people. And we saw that with this particular case. So they sued the township for $380 million. And out of that lawsuit came a settlement. And so that settlement then became the standard for all of the well pad, development going forward. So no matter, what the zoning hearing board said, or what the zoning hearing board saw at a hearing, they were under tremendous pressure from the industry. And I want to make this important point because I think it sways those zoning hearing boards, and I think it did in this case as well, because all the future cases, it was an approval, whether our experts said that it was going to be detrimental to public health or not. They took that threat, that real economical threat from the industry, and they said, well, if we deny these well pads, they're going to sue us again. They're going to sue us in federal court. We can't possibly come up against a challenge of $380 million. So it puts municipalities in a real bind. And I really want to try to make that clear because I think municipalities have a lot more power than they think. I think one of the reasons why we haven't been successful in other cases is because the case law is primarily in favor of the municipality. And so the municipality, by saying yes to all this stuff, they have the power, and they had the power then. They denied them then. They were sued with this ridiculous lawsuit that they could have fought. They decided not to. They could have won. They decided not to fight it. And then after that, it was just one bad decision after another because of the pressure of the industry. And I think that's really important because I want to make it clear to people that history matters when cases are going forward in a municipality. The history of the board, the history of the legislators and who's in power at the time, that really matters. And in this case, I really think it had an influence, and maybe one of the reasons why they were just like, okay, we're just going to approve it. We're not going to give any kind of reason why, because they didn't have a reason why. That's why they couldn't tell us why the public health experts were not credible in their eyes, because they didn't have a reason. And so this is why I feel like this case is really important. Nija, do you have anything to add to that?
Yeah, and I think we also had a question in the chat. I would just say about the previous decisions, I think that is really important, depending on where the case is brought, as you mentioned, either in federal court or at the local level, and depending on what the final status of the opinion is, it really can have large impacts, because depending on the court that issues the opinion, lower courts might end up actually being bound by those decisions. So even if they wanted to change course, they could potentially have no other option.
Yeah, and I think we did have a question. I'm going to try to bring up my comments window, because I believe I can actually pop this up in our live feed. And I know it's small, so I'll read it to you, Nija. This question is for you. It says, on the whole, Nija, are there judicial questions that would indicate they are serious on our behalf? I'm not sure if you can answer that, or if you have a...
Yeah. I would just ask if you could possibly clarify what you mean by judicial questions, just so I can better understand the question.
Yeah, that would be great. And while we're waiting for that, I'm going to go to Pat's comment. So much is done behind the closed doors too. Deals are made by way of that way a lot of the time, and that's so true. You know, Pat's one of our members that have been with us a long time. You know, really since the beginning, and you know, we were sitting in that room when the zoning hearing board came back with the decision that they had made the settlement. Sorry, I'm kidding. And you know, they just turned and like about face in their decision because of this settlement, this $380 million settlement, and we were just floored that how much pressure the industry put on them and how that closed door, because what Pat's really describing here is that whole deal, that whole settlement was made without public input. It was made behind the scenes, closed door, and because it was like active litigation, they didn't actually, per the Sunshine Law in Pennsylvania, they didn't actually have to tell the public what they were doing. And that's wrong. I mean, I feel like in this case, this is where the Sunshine Law should, the public should be involved in these decisions. The public should be the ones to say, hey, wait a minute, don't make a deal with the industry that's going to saddle you with this problem for the rest of, the township's existence, because now anybody that wants to come in and develop in Penn Township is going to be, is really going to have to deal with this settlement, these 8, conditions that we felt were really ridiculous. They were things that were already addressed in the, in the ordinance already. Okay, so we have an update. So what kind of questions might we get from one of the members of the Supreme Court that would give you an indication they're really considering or reconsidering how it was ruled? Yeah, that's a great question. And actually, Nija helped come up with some questions to help prepare Tim for that potential eventuality. So tell us a little bit about what you came up with, Nija.
Yeah, I think that's a great question, because that will really show kind of what direction that the Supreme Court could be leading and doing and issuing their decision. So I think first they will probably ask Tim just what is his stance on Dr. So's evidence being considered by the board, and I think they'll on that same in that same context, they'll probably ask opposing counsel why the board did give Dr. So and Nurse Dagley proper consideration, which I don't think that opposing counsel will. I personally think it will be interesting to see what their answer is, because it's not something that they heavily addressed and they kind of just swept under the rug. So I think that's the first thing that I would hope to see from the Supreme Court justices, is asking questions about that. And then, as Jillian discussed, and Tim as well, the cumulative impacts, I think if they ask questions about that, that would also be very helpful and indicate that they're really considering what these larger impacts are. Because as Jillian mentioned, whenever you have a single well permit, and oftentimes they don't consider the full extent of that, the impact of that well pad in combination with the other existing well pads. So I think those would probably be the questions I would hope to see the most, just to indicate that they're considering our side and the true implications of these well pads.
Yeah, and so when kind of taking up these types of challenges, there is a thought process, there is a whole strategy that we go through, and thinking through the potential outcomes. When we first started at Protect PT, that was one of the things that I found most interesting, because I didn't have a legal background, and so our attorney at the time, who was before Tim and then Ryan was the one who originally had this case before the zoning hearing board, but we were still with Fair Shake. Our attorney at the time kind of described it as a choose your own adventure, where if we either prevail or we do not prevail, here are the branches of things that could potentially happen as a result of that, either win or lose. And so what are kind of the ramifications of those. And so I feel like in this case, we considered some of the larger ramifications as well of, really that cumulative impact argument in particular, as well as the expert argument, because number one, with the cumulative impacts, if the Supreme Court says you have to consider cumulative impacts, then that can make a big difference for other folks that are fighting different different things down the road, because this is something that's really important that, like I said in the video before, the industry doesn't want us to talk about. They don't want us to talk about what the cumulative impact of all this development's going to be. They want to characterize it as non-industrial, which it is industrial. The Supreme Court has affirmed that. They're saying, well, it's only industrial temporarily, which, in our challenge to the substantive validity of the ordinance, they said, yeah, well, it's only temporary. So, it's not technically industrial, which is not the case at all. This is the line that the industry gives, but, it's not temporary. While there are only a few years that they have, or they're supposed to have under the law in Pennsylvania to develop a well pad, they can get an extension. Nigel, do you want to talk about that a little bit? Because I think that's a really important thing when you're talking about the impacts and how long residents could be seeing impacts from one well pad.
Yeah, and I would say even at the zoning hearing board, the likelihood of extensions are pretty clear. I mean, you've got, even when you're questioning experts, you've got answers where, oh, well, this is what we anticipate being X number of months, possibly a year. But they fail to admit that extensions are very possible. And as long as there's some adequate reasoning, especially if say, for example, operations have already begun, then they're not going to just say, oh, well, here's your end date. You have to shut everything down right now. That's just not how it works. So even in those cases, things could go on for several more months, several years in some cases. And so whenever that happens, if you have a nearby well operating or multiple at the same time, then you've got all this waste and pollution coming from multiple wells, overlapping areas, which residents just continue to suffer. And really, they have no say in when that will end. And even if one extension is filed, that's not even to say that another one could not be filed or requested. And it seems to be the case that most of those are granted, unfortunately.
Yeah, and this is something that we looked into, right? I had you look into, at the for the state statute, how, because it was 3 years that they have to develop and drill their wells. But we see this extension happen over and over again. We also see drill and operate permits being approved and just rubber stamped, regardless of the history of the operator. So this is another thing that we're actually challenging with our environmental hearing board case in September, the other case, and you can read about that on our website under our legal advocacy page. And so, Mary, I'm not sure if you can hear me, but maybe you could pop that up in the chat, just the page for our legal advocacy, because we outline in that case how this violation history is important, and this is something that the DEP should be considering when they give permits to operators, because it's very important. And in my opinion, an operator that has the privilege to do business in the state of Pennsylvania, where we have Article 1, Section 27 of our Pennsylvania Constitution that gives us the constitutional right to clean air, pure water, and the natural, scenic, historic, and aesthetic preservation of our environment and our resources for generations yet to come, that the folks that are doing business in this state should be held accountable to those state standards. They should be held accountable to our Constitution. And as it stands right now, the agency involved in making sure that is the case is not doing that. And that's a really important point when, at the local level, these decisions are being made, but then at the state level, decisions are being made. And all of this has the impact or the ability to influence the way well pads are built and operated in the state of Pennsylvania. So, that's not really related to this case, but I just want to mention that because it's something that we talk to a lot. And then, with the case of these experts, it's really important that if we prevail with this case, then, it could give more weight to other folks when they want to bring experts, and you have a zoning hearing board that says, well, we're just going to, take the industry's experts over, these highly qualified experts that the town brought forth. And it takes a lot of resources and coordination and, in some cases money to be able to do that. And we're really lucky to have partners like PSR that can do that on our behalf without having to put forth a lot of those resources. In one case, we're helping out some other residents, and their expert was $36,000, and that's a lot of money for a group of residents that just are trying to get a case, heard to get some protection on this infrastructure that could be really damaging to their community. So I want to put that out there. We are going to ask folks to donate, and we're asking on our webpage for people to donate because it does take a tremendous amount of resources. The time that we put in to researching the case, the time that we put into, the experts and preparing those experts, preparing that cross and direct exam testimony. I know, Naja, when you were interning for us for the summer, you helped us put together some of that cross examination, some of those questions, and as well as the direct examination for some of our experts. So I'm hoping that they're going to come to our case soon. But while we're waiting, tell me a little bit about what I want to focus a little bit on you, because I know you've had some great achievements recently, graduating law school, and you're going to be taking the board soon, and so tell me what you have planned next for yourself.
Yeah, so one thing I did just want to mention first, if that's okay.
Yeah.
I think as we're talking about the larger scheme of things, this case is undoubtedly huge and can have potential implications that, or if it goes our favor, could have, future cases, it could be very beneficial. But I think one thing a lot of people might not know is the statutory code in Pennsylvania is very deferential to DEP discretion. And so a lot of that stems from how the Pennsylvania legislature decides to write and update those provisions. So as Jillian mentioned earlier, the local judges can have a large impact, but so can local and even state legislatures and representatives. So looking at their viewpoints and what they value, and whenever you decide to cast your ballot, can really make a difference, especially if you want changes. So as things currently stand, the DEP doesn't necessarily have to provide explanation for why they make decisions, why they overlook certain violations, or what different agreements and requirements they issue, that they require before issuing a permit. So those are just those are things in a larger scheme of things that can be challenged by either writing your legislature, like the representatives who write that legislation, and just looking at the values of people that you might vote for. So I would just say that because I think that the legislation is in need of great reform. It's one of the reasons that Protect PT has to work extra hard to try and reach its goals, is because we have to comply with all of these existing statutes that are just heavily favored toward the industry, unfortunately. Yeah.
I think that's a really important point to bring up. At the end of the day, your vote matters and your voice matters. Whether it's in a small case like this, where you're making public comment, or maybe doing fact testimony, or when you cast your ballot and your ability to talk to your legislator and let them know. There was recently a study that came out with Environmental Health News. We're going to be doing some more on that this summer. But and you can actually find the videos and links on our YouTube to those videos with the Environmental Health News organization. So Christina Marusik, their reporter, did a study. My kids were actually some of the kids that were studied as the folks that didn't live around as much fracking because of where we're situated, and because we have fought so hard to try to get these well pads away from people as much as possible. We're further away than others, especially those that they studied in Washington County who live, literally it's in their backyard. And so they found, and this was studying, we actually had to wear air sampling equipment where it took in a VOC sample of our air. We wore that for a day, and then they came back and did it again. So I think we had to do it twice. And then they also did urine samples so they could see what chemicals were in the bodies of the people that were living near this type of infrastructure. And Christina Marusik, the reporter, reached out to some legislators, and actually, Mary, I bet she could put the link up to that article. But there were some legislators that signed on to a letter saying, hey, you know what, we need to look at this a little bit more in the state of Pennsylvania. And then there were some legislators that didn't even acknowledge or didn't want to talk to Christina about the study at all. And so it's important to note that your vote matters, and also talking to your legislators after they're elected. So if you have folks that maybe you supported in this last primary, maybe you're going to support in a future election, it's important that if you talk to those folks when they're campaigning and they make certain promises, that you hold them to that. You hold them to the promises that they're making, because when they get elected, they're working for you, just like the township works for you, and the DEP should work for you. If you're a Pennsylvanian, the DEP should be working for you. And a lot of times, it takes groups like ours, it takes individuals that are willing to stand up and say, we're not going to accept this, for change to be made. So we're hoping that change will be made soon. Thanks for bringing that up, Nija. I have the link up here to the EHN Fractured series, so check that out. And we're going to be doing some more work on that over the summer with our new batch of summer interns. We're excited that we're going to have new summer interns here. So the case has not started yet. They haven't broken from the second case yet. So we're still waiting for the Supreme Court. But Nija, tell us a little bit about what you're going to be doing next in your journey.
Yeah, so I'll be taking the bar exam for California, actually. And unfortunately, the way that the bar exams are set up this year due to COVID, they're kind of overlapping in a lot of states. So I do hope to take other states as well, possibly Arizona and Pennsylvania. And so, yeah, so as Jillian mentioned, I just finished law school. I've been with Protect PT for a little over 2 years as I've been able, and it's honestly been a great experience because I grew up in this area and my dad still lives in this area. So it's a lot of values that I really cherish and care about. So after I pass the bar, I'll be working on some intellectual property matters and also environmental things, but focused kind of on patents. And as I'm able, I still am planning to keep in contact with Protect PT. And if there's, things that I can do to help out when I continue to have time, I'll be sure to do so. And it's been a crazy adventure, but I feel like we are making progress, and it's an uphill battle for sure. But there have been so many instances where you feel like you can actually make a difference and stand up to the big industry guys. So
Yeah, yeah. So we wish you the best of luck in everything that you're doing, and we're so happy that we were able to spend time with you. The summer that you were here with us, it was actually 2019 was like the last summer where we had interns in the office. So it was just like it was really great getting to know you and your dad, um, and we had a really fun. That was a really fun summer. We had a lot of great in-person events, and that's something that we miss
Mhm.
here. But we are bringing on some new interns this summer, so keep looking for that. And we are going to continue to do our lunch and learns. So if you have never experienced one of our lunch and learns, you should definitely do that. They're on our YouTube channel. We have them every month now. Last year when COVID happened, we had them once a week, but that was a lot of preparation, and there's so many important issues to talk about. We're actually going to be talking very shortly about at the end of the month, we're going to be talking about the fracking waste, and the importance of figuring out where that fracking waste goes. And I'm going to try to pop up on the screen some information on that while we're waiting for the Supreme Court, because it's taking a long time for them to get to us. But if you give me a minute, I will pop that onto the screen and to show everybody what the lunch and learn is going to be while we're waiting for them. So this is our community lunch and learn that's going to be on the 25th, which is next Tuesday. We're going to be talking about new bills in Ohio and Pennsylvania that expose you to radiation or radioactive oil and gas waste. So just check that out. It's going to be on our YouTube. Dr. Stoles, who we have heard from before, he's been on previous lunch and learns, and also Teresa Mills from Ohio. So John Stoles is a doctor, a professor at Duquesne University here in Pittsburgh, and Teresa Mills works with a group in Ohio, and really just talking about oil and gas waste. There's a lot of injection wells in Ohio, so it's a really big deal, and so that is not to be missed, because we're going to give a lot of information. And with those lunch and learns, it is a lot of information, but we don't often have some really like direct actions that can be taken. But we are going to have some direct actions that can be taken after that lunch and learn, and that all happens behind the scenes. Our wonderful staff, really prepares that material ahead of time. It's going to be on our website, and it's really important that folks learn about these things, because whether you are in, Nigel, you're in Arizona still.
Yeah, currently. Hmm.
So whether you're in Arizona or you're in Pennsylvania or you're in Ohio or you're in California, there are some things that are happening in Ohio that could really change some of the products that we see on our shelves at the hardware store. And that is pretty scary, to kind of think about some of this oil and gas waste that's being used in unconventional products that we might not think about. But you can actually sometimes get this on the Lowe's shelf or the Home Depot shelf, and you might not know that what you're really buying is oil and gas waste that could be potentially radioactive. So make sure you tune in for that. And they are still on their second case. um,
Yeah, one other thing I would just say is even if you can't be involved full time, once things get back to normal where Protect PT can host in-person events. I was lucky enough to be able to go to several of those, and sometimes they're either on weeknights, on weekends. So if it's something that you're really interested in, you can go out and learn a lot. One thing that comes to mind in particular was an event at the park where we got to just talk with the local community, and I think even people just even there didn't realize how close and how much they might be impacted by these well pads. So even if it's something as simple as a few hours on the weekend, like Protect PT really does appreciate any time and support that we can get, because it really does help with the long-term goals and efforts of focusing on community health. And I think there's,
Unmute.
I think you're muted, Jillian.
All right. Yeah, thanks for mentioning that. It's really important, and we have lots of volunteer opportunities. So don't hesitate to reach out if you have some time to volunteer, or come out to one of our in-person events, which we hope will be happening again soon. Yeah, there's a question for you, Nija. So how common is it from one state to the other in terms of the bar exam?
So I'm not sure if you're asking maybe like how different are the exams, or if they might be transferable. But just as a general matter, states, I think there are 37 states that have, they'll do like reciprocity where they'll accept those things. Unfortunately, California is not one of them, but in general, most states have 2-day bar exams. One day is comprised of what's called the multi-bar or multi-state bar exam, and it's basically a lot of federal law. So you have to know all of those things, and it ranges from 6 to 7 hours depending on the state. And then the second day will be state specific law. So the states that do allow for reciprocity, you wouldn't have to take that first day again, but you would have to take the state specific law. And those state laws can vary extremely just in all different aspects. Like even just going from Pennsylvania to Ohio, you could have significantly different requirements, whether procedural or substantive. So that would be the most different thing. And then, of course, I think New York's another big one where they just make you take their exam because they just want to. So it just kind of depends on the state.
Yeah, and you know what? For those folks watching that maybe would want to intern for Protect PT in the future, what are some things that you think would be valuable for interns that are focusing in law, in particular? What are some valuable things that they should maybe focus on in law school?
So I think definitely research and writing, that's huge. And I mean, wherever you go, that's going to be huge. But Protect PT in particular, the environmental law kind of stems from, you have the EPA at the federal level, who then delegates information and regulations and whatever enforcement requirements in general down to the Pennsylvania DEP. So I think focusing on administrative law would be extremely helpful. And if you can take that in your second year, it's not part of the first year required courses at most law schools, but in the second year, it's a course that you can take. And I think that is very helpful because it kind of explains how the rulemaking and legislative process works in general, which, as we discussed earlier, is kind of something that needs to be revamped. So that would be really useful. And then, the constitutional law, just as Jillian mentioned, that's a first year course. So everyone would be required to take that, but focusing on standing requirements, because if you can't make that the showing of standing, then your case will be dismissed before you even get started.
Yeah, absolutely. And that's why, and I want to mention this again for those that are just tuning in. That's why it's so important for Protect PT to have membership. So if you're not a member of Protect PT, or maybe you are and haven't renewed that membership recently, make sure you do so. And I want to encourage folks to donate, because none of these experts can happen. None of this legal advocacy can happen without donations from local folks like you that might be watching, and hopefully waiting to hear from the outcome. And I know that one of the questions that we kind of talked about towards the end of the video with Tim was, and I know this is like a long, long video. We were hoping to be, with the Supreme Court by now, but they're taking their time. And that brings me to another thing. They're going to take their time to decide on the case, and to decide what the implications are of their ruling, and really just give us an idea of what they're thinking. So that's not to be rushed. So we will keep everyone updated on what happens, but just keep up to date on our website, and become a member. because if this is something that's going to be happening in your neck of the woods, if we can help you out at all, we're willing to do that. We also, like I said before, give mentorship to folks that maybe already have an established group, and those group of neighbors, maybe some need a little bit of direction as to, what experts should I have at my local hearing? What are some of the issues that are going to really come up in this hearing? And so what we try to do is get together with neighbors and find out what their concerns are, what their major concerns are. And then we look at the really development as a whole and say, okay, well, so these are their concerns. And then as the well pad develops, there are going to be additional concerns that maybe they're not even aware of at this point. And so we kind of lump all of those together and really flesh those out. We have a document that we've used for pretty much every hearing that kind of goes over these different things, and we can share that with anybody that wants that information, that's really working to protect their community. And it just really goes over some of the main points that folks want to point out at the hearing. I will say you can do this without a lawyer, but it's so much easier to have a lawyer to do it, especially when maybe you don't have the experience doing this in the past. And it's important to get all your ducks in a row, to get your experts, your fact witnesses, and everything else together. And guess what? They are finally done with case 2. I think that so we're gonna go to our case now. There are going to be a couple minutes between the cases, so I'll put the case up and we can it'll come up when it does. But I want to thank you, Nija, for being with us today, and thank you for all the work that you've done with us at Protect PT. Nija's going to be working with us until about August after, and then she's going to be going to California to live and to start a new career, a new chapter in her life. So we wish you all the best, and we just really appreciate all the hard work that you've done with us. And we're going to go ahead to the Supreme Court now. And thank you so much for joining us this morning, Nija.
Yeah, thank you for having me. And just one thing I want to say is I know it took a little bit to get to the case this morning, but I'm hoping that means that our case will be equally considered and given the proper questions that it deserves. So, and thank you, Jillian, for everything.
Yeah, thanks so much.